welcome to Child and Crime Courtroom Confidential, a gripping true crime channel where the complex world of criminal law and child protection takes centre stage. Hosted by me, B, an experienced child protection and criminal lawyer with both defence and prosecution experience. This channel delves into the intricate details of real-life cases, offering a unique perspective that only somebody deeply entrenched in the legal system can provide. Our mission is to shed light on the often shadowed facets of justice, exploring the stories behind the headlines, with a focus on victim advocacy, prevention, and the pursuit of truth and justice. So join me as we unravel the mysteries of real crimes, involving real people and those most vulnerable members of our society, our children. Today's case is that of Carla-Nicole Bone, who was born on the 7th of April 2001 and was killed on the 13th of May 2002. Andrea Bone spent most of her young life in Rosendale, a small, quite rural place in the UK. Her father, Carl Bone, still lives in nearby Staksted. She attended Alder Grange High School and had a number of jobs in the area, none of which lasted very long. She left the valley in May 2001 to move to Scotland. Carla-Nicole Bone, her daughter, was born on the 7th of April 2001 at Burnley General Hospital. Her mother at the time, Andrea Bone, was 19, and her father, David Mullaney, also known as David Shorrock, was 18. Andrea and Carla-Nicole lived with Andrea's father, Carl Bone, for the first few months of her short life. Then, in May 2001, they moved in with David's mother, Liz Berry, in Grampian, in Scotland. They later moved into a caravan in the Bridge of Don in Aberdeen. That was sometime prior to January of 2002. Carla and Andrea were known to both Grampian and Aberdeen social services. After the family moved to the caravan in the Bridge of Don, David's mother, Liz, says that David lost his job, he lost weight, and for a time he turned to drink. The pair didn't stay in a relationship, but Andrea was already pregnant with another child when they separated. And although they didn't stay in a relationship, after this really sad events in this case transpired, Andrea actually married David in August of 2002 in what some call a sham marriage, weeks before the trial started, to ensure that he retained rights to access with their second child. But let's just roll back a little bit. So we're sometime towards the end of 2001. And Carla-Nicole is only a few months old. Andrea leaves David to start a relationship with Andrea McClure, who is known as Sandy. He is from Oceanblay in Kincardineshire, and at some point, taking into account the information that I can find, between September 2001 and January 2002, they begin living together at the caravan that Andrea had previously shared with David. And then they moved. They moved to a remote cottage near Huntly in Aberdeenshire, where again they became known to social services. The family was considered to have problems. They were deemed vulnerable by social services, but not vulnerable enough for them to take clear steps to protect Carla-Nicole Having identified and pulled in a vulnerable young single mother, 3 distinct personality disorders, and low intellectual or cognitive ability, being in the bottom 5% of the population, both of which would sway the power dynamic in McClure's favour, it became clear that McClure had isolated Andrea and Carla-Nicole. Now that's a common tactic for domestic abuse perpetrators and for child abusers. She was 19 to his 26. So again, the balance of power is tipped to him. And another standard tool in the perpetrator's playbook is that they often either insist on moving in very quickly, getting married very quickly, or they get the victim pregnant early on in the relationship. And we know that McClure and Bone had quickly started to live together when they got into a relationship. We also know that Andrea had left her family, who were all in Rosendale in the northwest of England, and moved to Scotland, where she was somewhat isolated to start off with. But then McClure has taken her from the area in Scotland where she had started to settle and moved her elsewhere, so she was entirely isolated. She had no support system. It's not clear if there was any domestic violence in their relationship, but we do know that he was abusive to Carla-Nicole, and the two usually go together. Now, we do know that Andrea said during the trial that she was terrified of McClure, so that gives some indication of the kind of personality that he was. Witnesses said that the child would become extremely distressed when she tried to use the baby walker and was dressed in dirty clothes in the caravan where the family lived shortly before Carla-Nicole died. There was no agreed care plan by social work and health staff, and there was also a reluctance among some to challenge Andrea Bone about her standards of care in case she disappeared again. And we see this quite a lot with families that are known to social services, because there is no centralised child protection register in the UK. They are held by specific local authorities. People can evade notice and evade action by moving around. We know that bruising had been found on Carla-Nicole's body by various care workers, social care people, healthcare workers, but a lack of continuity of care meant that changes to the level of injuries may not have been spotted. Aberdeen City Council said that it had responded to 2 allegations of neglect while the family were living in the caravan. The first claim was made anonymously in November 2001, while the second came from the girl's paternal grandmother, Liz Berry, who we've already talked about, and that was on the 4th of April of 2002, just 6 weeks before Carla-Nicole was killed. So had they stopped and paid attention at that point and taken decisive action, the outcome may have been very different. Social workers visited following these referrals and decided that although the couple needed advice and help in caring for the child, the overall standard of care was adequate, and concluded that there was no need for formal protection procedures. They said that McClure cooperated during the visits, and there was no evidence that he would be a serious risk to Carla-Nicole's welfare. There is no record that any information was received at any time by the relevant agencies that Carla-Nicole was subject to physical abuse by those caring for her. there are hundreds of families in Aberdeenshire whose parents are struggling a bit. There's always a fine balance to be struck between whether a mother is doing well enough or whether they need to come in with a child protection plan. And Carla-Nicole was not one of the 289 children on the child protection register in that authority, but that she had regular contact with health visitors and social workers during her life. Now, I understand this stance that local authorities take and that the law provides for. So, case law has made some very specific indications of what will justify removal of children from a home environment. And there needs to be a risk of serious harm. That can be physical, emotional, or psychological harm. But there needs to be a risk of serious harm. And if we're looking at something along the lines of neglect, say, for example, then the courts have said that we're not to expect perfect parenting. We're just looking for good enough parenting. In other words, the child's basic needs, both physically and emotionally and psychologically, are being met. But Liz Berry was very clear that she had phoned them 6 or 7 times and that she blames social services. And at the end of the day, this is such an emotive subject that, of course, the family that are left behind and many members of society will say, you know, it's got to be the fault of professional services. The reality is that the only person to blame is the individual who commits the act and those who were in a position of trust and did nothing. If they knew about it, specifically knew what was happening. And there are always learning opportunities in these cases. And one of the biggest learning opportunities I think that can be taken is that if a family member has rung you as a service 6 or 7 times, they are worried. People don't have the time and energy to focus on ringing that many times in a short period if there isn't significant concern on their part. And services need to take that seriously. And I think often the men in the household are glossed over, really. So there will be lots of kind of, let's have a look at how mum interacts with baby. But not, let's see some interaction between the man that's living in the house and the baby. Let's see how the baby reacts to this person and those types of things. And I think if that had have happened, given the information that was provided by neighbours while they were living in the caravan, then potentially social services would have realised that Carla-Nicole was scared of him. And one final thought on that subject is where they see bruising, they should always, always have a child protection medical. Now let's move on to the 13th of May 2002. A heartbreaking day where a little girl who was 13 months of age and had a whole life ahead of her lost the opportunity to see that future that was laid out before her. Carla-Nicole died following a frenzied attack by McClure, in which, and I can't believe I'm going to describe this has got to be one of the most heartbreaking cases that I've ever dealt with. He flung Carla-Nicole from wall to wall by her ankles like a pendulum, splitting her skull. Exactly what happened will become clear when we visit what happened at the trial, and I'll offer you a very clear trigger warning now. The details of this attack are heinous and demonstrative of the worst type of people in our society. Those who prey on the vulnerable and treat women and children as objects to do with as they please. Detective Inspector Ian Burney of Grampian Police described the death of Carla-Nicole as the worst case of child abuse he had come across in his 21 years as a police officer. And certainly in my time in the legal profession of nearly 25 years, I would say it's one of the worst cases that I've come across. McClure was someone who had clearly gone too far in these circumstances, Detective Inspector Burney said. Our investigations uncovered a catalogue of assaults and cruelty against a defenceless child by a heartless man who displayed increasing levels of violence. His brutal treatment of that little girl bordered on the monstrous. As far as Bone is concerned, meaning Andrea Bone, the mother, as far as Bone is concerned, the charges reflect her actions, or more importantly, inaction, in the overall behaviour she displayed in failing to protect her own child. She attempted to manipulate us, the witnesses, and the accused, McClure, in order to minimise her role in the shocking circumstances which led to the death of Carla-Nicole. All the officers in the case have been upset and deeply affected. And I can only begin to imagine, as a frontline police officer, how much this case would affect you for, well, probably forever. A spokesperson for children's charity, the NSPCC, said Carla-Nicole's murder was shocking but sadly all too familiar, and called for tougher legislation to protect children. He said, for the last 30 years, at least one child has been killed by their parents every week in the UK. There is now a groundswell of public concern about the number of children dying from abuse in this country. We urge the government to act swiftly to stop further child abuse deaths. And Margaret McKay, Chief Executive of Children's First, added, the death of any child is a tragedy, and never more so when at the hands of someone they depend on for protection. It is a sad fact that more children are victims of homicide in their first year of life than at any other age. This is in no small part due to parents and carers failing to realise the fragility of babies and young children. Child protection is everybody's business. Our message to friends and neighbours is, if you are worried about what is happening to a child, trust your judgment and don't give up. And I'd agree with that sentiment. If you think that there is something not right about the way that a child is being treated, or something is happening to that child, make sure you report it. And if nothing is done, keep doing that. Keep reporting it, because the more times that that is recorded on the professionals' files, the more concern will build in their minds. But the other key is keep a diary of the things that are worrying you. What have you seen with the date and the time? Because that type of evidence can help to enable those services to actually do something. Now, at the trial, which was held at the High Court in Stonehaven, both McClure and Andrea Bone were found guilty in September 2002. McClure of murder and Bone of both culpable homicide by virtue of her failure to do anything to stop McClure. And child cruelty. And she was sentenced to 3 years custody, and McClure was sentenced to life imprisonment with a minimum term of 13 years. The legal parties in the case were James Riley QC represented Sandy McClure. Jack Davidson QC represented Andrea Bone. And the prosecutor was the Procurator Fiscal Drew Mackenzie. Now, it's worth looking closely at the charges that these two faced, because they paint a picture and they set a scene. So, the first charge is that between the 1st of January of 2002 and the 12th of May of 2002, at caravan number 19, Seaview Caravan Park, Bridge of Don, Aberdeen, and at Conland Farm Cottage, Forg, Huntley, Aberdeenshire, on various occasions treated Carla-Nicole, a child under your custody and for whose care and protection you were responsible, cruelly and unnaturally. And the particulars of that treatment were set out like this. So, repeatedly feed that child forcibly by pressing or forcing food into her mouth and inducing her to swallow by holding her mouth shut and pinching her nostrils. Scooping up vomit from her bib and putting it back on her plate. Repeatedly slapping her on the legs, hands and buttocks. And without regard for her physical strength and alertness, repeatedly forcing her to stand unsupported or unaided for prolonged periods of time in an attempt to compel her to walk. And the backstory to that last point is that McClure was convinced that she should be walking at the time in question. So that was when she was 12, 13 months of age. And if she wouldn't do it of her own accord, he was going to force her to. The mind boggles, but that's the mindset that McClure had. And then the second charge is that on the 13th of May of 2002, McClure, in the presence of Bone, assaulted Carla-Nicole by doing the following: compelling her to stand against a wall, repeatedly lifting her bodily and knocking her against a wall as a means of forcing her to stand unaided, pulling and twisting her legs, slapping her on the face, hands and legs, gripping her bodily and compressing her body, gripping her by the neck and forcibly pressing her bodily against a wall, knocking her to the floor, making her strike her head repeatedly against the floor and against a stereo unit, causing injury to her mouth, thrusting her forcefully to the floor, injuring her right leg, dragging her bodily and lifting her both bodily and by her neck, and finally picking her up by her ankles and with her facing the wall, swinging her from side to side like a pendulum, so she repeatedly struck her head and body against a wall. Andrea Lorraine Bone did witness and countenance this criminal conduct towards Carla-Nicole and did willfully fail to protect her and ensure her well-being or to seek any medical treatment for her injuries. Now, Carla-Nicole's injuries were so severe that she later died at the Royal Aberdeen Children's Hospital. And during the trial, the prosecution case was that McClure had subjected the child to torture and was disciplining Carla-Nicole for refusing to walk or for not eating fast enough. He told the police, when interviewed, that it started with not excessive smacks, stating, "It was the way I was brought up and it never did me any harm." Well, my answer to that, Mr. McClure, is that you are now sat there facing murder charges. So yes, it did do you some harm. It created a very problematic perpetrator of severe violence. The two key witnesses at the trial were Andrea Bone and Jason Durand, who was 16, and a friend who was there at the time of the attack. They also called Professor David Cook, a medical expert, in relation to Andrea Bone's mental state. But they say words paint a picture, so let's look at what those witnesses said about what happened. So first of all, let's look at Jason Durand. He told the court the following. He said that he was a regular visitor to the cottage and that he had stayed at the cottage on the day that Carla-Nicole died. And then he goes on to say this in his own words. "I recall that on a number of occasions, both Andrea and Sandy would get frustrated. I remember Andrea and Sandy had a problem getting Carla-Nicole to walk." Well, actually, he calls her Nicole, so I'm going to use his words. So, "I remember Andrea and Sandy had a problem getting Nicole to walk. This frustration would build up, and after Nicole had fallen on 2 or 3 occasions, she would then be smacked. On another weekend, Andrea became frustrated that the child wouldn't eat. I heard her shouting at the child, 'Eat your effing tea.' McClure then took over feeding the baby, but he also became frustrated. And about 5 minutes into feeding her, Sandy began to force feed Nicole. On the 13th of May, Sandy started hitting Nicole 3 or 4 times with a lot of force. She was standing up and she fell to the side. He picked her up and he banged her against the wall and floor. Andrea sat silently on a couch, sipping coffee and smoking a roll-up. The child went floppy and didn't respond to her name. Sandy jumped up with the child held out in front of him. He started saying her name and she didn't respond. She was all floppy. Her head was tilted right back. Sandy had her head under water. He put some water on the top of her head to see if she would respond to that. She started making groaning noises. She was groaning. Sandy said, "She's going to be all right. We'll take her down to the hospital." Sandy said her eyes were rolling about in her head. She was just groaning. There was no response from her. And then he goes on to recount that he, McClure and Bone drove Carla-Nicole in McClure's car to the hospital in Huntley. Now that's a 16-year-old boy who's had to sit and watch that. And you can understand why he wouldn't try and stop a 26-year-old man. And I can imagine that he wouldn't know where to start with how to get him to stop. Now, Andrea Bone also gave evidence. And she told the trial court that McClure's character changed completely. It was a side of him I have never seen. He was like evil. His face was full of evil. And she went on to tell the court that Carla-Nicole had been standing against a living room wall. And I have a really hard time with this. Getting a baby to stand against the wall is utter ridiculousness. Andrea goes on to say that she remembers Sandy having his fingers around her throat and dragging her up the wall, then smacking her against the wall really, really hard. You could actually feel it coming out at you. He was shouting something. I didn't know what he was shouting. I couldn't understand him. He then turned her upside down and held her by the ankles. I couldn't move. Her face was facing the wall, and he was swinging her from side to side like a grandfather clock. He was going really, really quickly. Her head was hitting the wall, but I couldn't see how hard because he was blocking. He picked her up in his arms and I wanted to get her, but I couldn't move. It looked like she'd fainted. Sandy stood her against the wall again and she kept falling over. So you can see there the detail that she can recount because she was watching it and it was vivid in her mind. And I have less concern about the fact that she didn't react act and do something at that point, because shock could potentially render you completely unable to move or speak. If you see that, you know, we have a parasympathetic nervous system that does one of four things: fight, flight, freeze or fawn. You don't get to choose which one of those your body does. The mammalian part of your brain chooses what it's going to do, what the right reaction is in that circumstance. So I understand that a little bit more than the fact that he's been doing this kind of behaviour with increasing intensity for 4 months and she's done nothing. That I can't excuse. Asked by her barrister, Mr. Davidson QC, why she had not come to her daughter's aid when McClure force-fed Carla-Nicole during the preceding 4 months, or made her stand for long periods in an attempt to get her to walk, Bone said, "You've seen the size of him. He scares me at times." Well, my answer to that would be that's only at times, and there is always a way to summon help of some kind. Under cross-examination by the prosecutor, Drew Mackenzie, Bone was asked why she had not told health visitors about the problems. And she said, "Because I was never alone with the health visitor. Sandy did all the speaking for me." And again, this feeds into the common characteristics in domestic abuse perpetrator. So it's often the case that they will speak for their partner. They won't let them be alone with professionals. They'll control where they go, who they go with, how long they can take, whether they have access to a phone. They will analyse the phone records. And I don't know whether all of that happened here, but it certainly sounds like he was speaking for her and not letting her be alone with professionals. So it's more complicated than simply you should have done something and you didn't. But there's always a way. If this is describing you as a mother and you don't know what to do to stop the mistreatment of your child, there is always a way to notify somebody that there is a problem and that you need help. And there are organisations whose sole job it is to help people to understand how to safety plan, how to get out safely. And it's important that even if you have to borrow somebody else's phone so that your partner doesn't see that you've made a call to that organisation, that you contact somebody like that, because the most risky time is when you try and extract yourself. But it can be done, and it can be done safely. Another witness in the trial was psychologist David Cook. And he gave evidence that Andrea Bone had 3 personality disorders and that her intellect was in the bottom 5% of the population. He told the court that we are dealing here with a lady whose low level of intellectual functions is such that it will lead to her inability to make decisions in the heat of the moment. She was subject to social and geographical isolation and suffered from avoidant personality disorder, dependent personality disorder, and borderline personality disorder. Now, just to give a little bit of background about what that means, because people throw around this phrase, oh, they must have a personality disorder, quite a lot. There are different types of personality disorder and they present in different ways. So what are we looking at here for Andrea based on what Dr. Cook has diagnosed? So avoidant personality disorder. This is going to be a person who has a big fear of rejection or criticism, low self-esteem and feelings of inadequacy, little social involvement or complete avoidance of social situations, preoccupation with whether people disapprove of them, self-isolation, social anxiety, and anxiety or nervousness around intimacy. Then we've got dependent personality disorder. And that is, there is a clue in the title there. So these people are often in a relationship where they are heavily dependent on the other party. They have an excessive need to be taken care of by other people. And they rely on people close to them for their emotional and physical needs. Other people might describe them as needy or clingy. And they might often avoid expressing disagreement or creating conflict in relationships because they fear losing that relationship. Now you can see that there's already an overlap there. So we've got people who, they've got low self-esteem and feelings of inadequacy and they fear rejection, linked with being dependent on other people and fearing losing relationships. So avoidant and dependent, they're almost in the same camp, so to speak, even though they're different. Borderline personality disorder, slightly different. So the key presentation is emotional instability. So the psychological term for that is affective dysregulation. People with borderline personality disorder often have disturbed patterns of thinking or perception. So they can have mental distortions, so it's cognitive or perceptual distortions about how they see the world. So that can be paranoia, thinking that people are angry at them if they're not, aligning with unusual worldviews. They tend to have quite impulsive behaviour. So they're emotionally unstable and they have impulsive behaviour and they've got distorted patterns of thinking. They also have, generally speaking, intense but unstable relationships with people. So this might present as things like making frantic efforts to prevent being left alone, constantly texting or phoning a person, suddenly calling someone in the middle of the night, physically clinging onto that person and refusing to let go, or making threats to harm or kill themselves if that person ever wants to leave them. And despite that evidence from Professor David Cook, the jury still felt that Mum absolutely ought to have acted to protect Carla-Nicole. But all of this information about her personality, mixed in with the fact that we know the type of personality that McClure is presenting as, gives some idea of why it might not be as straightforward as, he's hurting your child, you should protect your child. Again, I go back to there is always a way, but you can see how that might all play in to her feeling unable to change what was happening. Now, in terms of Carla-Nicole's injuries, in hospital, the doctors found that she was unconscious when she arrived. She was covered in bruises, had a skull fracture and swelling of her brain. She had retinal hemorrhages, but despite surgeons' best efforts, she was left on life support, and after a number of days that was switched off because there was no possibility of her recovering. And I just keep envisaging what the result of McClure's actions would look like on a 13-month-old baby, and what Carla-Nicole must have felt, the panic, the fear, the pain, the inability to do anything to stop what was happening. The sheer panic of looking and seeing that your mum is sat there watching as this is being done to you. Dr. Elizabeth Myerscough told the court that she had no doubt that the child was a victim of fatal child abuse, and a post-mortem examination uncovered bruises to her face, forehead, around her jaw, the left side of her torso and her back. And Dr. James Grieve, a senior lecturer in forensic medicine at Aberdeen University, said that Carla-Nicole's brain had been damaged by being shaken and knocked against hard objects. And, you know, we think of shaken baby syndrome, but when you think about being swung repeatedly so that your head hits a wall, the amount of force that would build up as it's done repeatedly would be immense. And it surprises me, honestly, that they're not describing even worse injuries, but I really dread to think how it would have left that little baby. The outcome of the trial can be summed up in the sentencing comments by Lord Abernethy at the High Court in Edinburgh on the 14th of November of 2002. He told McClure, "Your actions were a cruel and unnatural treatment of a young child. When you became frustrated while she resisted your efforts to care for her, your temper got the better of you and you took it out on the child. You exploded into a level of violence and ferocity on the morning of her death, which was altogether on a different scale. It seems you completely lost your temper, and in that state of mind assaulted her so severely she died." McClure was sentenced to life in prison with a minimum term of 13 years before he would be eligible for parole. And I think those sentencing comments, if I'm honest, are very polite compared to what I would have expected, given the heinous nature of this offence. In sentencing Bone, the judge said that the loss of her child would be a heavy burden she would carry for the rest of her life. He added, "You woefully failed to protect your daughter when your partner assaulted her. You were under a legal obligation as Carla's mother to do what was reasonable to protect her. And, as the jury have found, you woefully failed in that obligation in a way that contributed to her death." Carla's mother, Andrea Bone, was found guilty of culpable homicide for failing to intervene during the attack, and she was sentenced to 3 years in a Young Offenders Institute and would be supervised for a year following her release. Lord Abernethy added that the couple had loved the baby and had shown remorse when she died, but their misguided care amounted to a catalogue of abuse. Andrea Bone's second daughter, Nikita Tanya, was put up for adoption. Now, following the trial, Bone submitted an appeal on the 28th of August of 2003 and later made 6 unsuccessful applications for bail, telling the court that she was subjected to considerable abuse by other inmates at Cornton Vale Women's Prison in Stirling and had been placed on increased medication to combat suicidal tendencies. And I am not surprised that she was treated poorly by other inmates. There tends to be, even among inmates in prison, a particular moral code, and one of those boundaries is harming children. Now, in September of 2003, just a month after the appeal was submitted, 3 appeal judges stated that Bone could be released on bail once a suitable address could be found. Now, there were a couple of attempts at finding somewhere. So first, there was a plan for her to be accommodated by a Scottish housing charity, but that fell through. Then there was a proposal that she stay with a 43-year-old male pen pal who she had only met once but had been writing to regularly since February 2003. And he had offered a room at his home near Edinburgh, but that was ruled out. And then finally, on the 21st of November of 2003, the court gave her what she so desperately wanted and agreed her bail to reside in an unidentified bail hostel. She was later returned to prison, though, because she was evicted from that bail hostel, which was in England, not in Scotland. And then on the 30th of April 2004, Bone was once again released from prison, this time to live with her new partner, who was a recovering drug addict in Rochdale. Her advocate told the court, "She has formed this relationship which appears to be a positive one. He is a recovering heroin addict, but he appears to be making good progress. The pair have applied for a joint tenancy." So at that point, she was released on bail until the appeal could be heard. And that happened on the 18th of November of 2005. The appeal judges were Lord Justice General, Lord McFadden, Lord Wheatley. And the advocates in the case were acting for Andrea Bone was Margaret Scott QC and Mr. Barr of Bennett and Robertson. And the Crown agent was Mr. Brian McConaughey. Mr. Brian McConaughey QC. There were 4 grounds of appeal against the conviction. Leave to appeal was granted, but only on certain grounds. So, in relation to charge 2, it was in relation to the ground that parental responsibility towards the deceased does not involve criminal responsibility for failing to protect the child or to intervene in the assault perpetrated by the co-accused, which arose in circumstances where the appellant was powerless to intervene. So in other words, they're saying she shouldn't be criminally culpable because she was powerless to intervene when McClure was attacking the baby. And the second was that there was insufficient evidence to entitle the jury to convict, and in particular in respect of each of the following. There was insufficient evidence to entitle the jury to find that the appellant had countenanced the murder. There was insufficient evidence to entitle the jury to find causation, that her alleged failure materially contributed to the death. And the judge failed to direct the jury properly. And that in the assessment of what was reasonable in respect of the alleged failure to protect the child, regard should be had to the particular circumstances of the appellant, notably her individual limited ability to react and her particular vulnerability as stated in the evidence of Professor Cook, which was relevant in this regard and not restricted to the issue of diminished responsibility. And that as a result of each and all of the above, there was a miscarriage of justice. Now, in terms of reasonableness, the essence of charge 2 as laid against Andrea Bone is that she witnessed and countenanced McClure assaulting Carla-Nicole, and that she willfully failed to protect her and ensure her well-being, and that resulted in her death or contributed to her death. It was common ground that willful failure to protect involved a willful failure to take steps that could reasonably have been taken to protect her. And the jury, therefore, in the appellant's view, required to understand how the test of reasonableness should be applied in considering the appellant's inaction and what factors properly could be taken into account in such consideration. So essentially what they have said is that Andrea Bone's failure to protect Carla-Nicole has to relate to what was reasonable for Andrea Bone in all of her circumstances to take, and that the trial judge didn't direct the jury about that properly. Now, I'm going to tell you what the trial judge said before I let you know what the appeal court decided, because I think it's important to understand that background, and I appreciate for some of you it might be a bit too much in the way of legalese because it's the trial judge's words, but it is really important, and he was speaking to the jury, so in theory it should be easy to understand. So he said as follows to the jury: these factors included her being scared, her seeing a look of evil on the co-accused face, the fact that she was 8.5 months pregnant and isolated socially and geographically, the factors that Professor Cook brought into evidence. The evidence which bore on whether the appellant, if acting reasonably, would have intervened to attempt to prevent the assault, included her size and strength compared to the size and strength of McClure, the advanced stage of her pregnancy, her geographical isolation, her social isolation. Plus, there was evidence from Professor David Cook, a clinical and forensic psychologist, about her level of intellectual functioning and certain personality disorders by which he found her to be affected. Her level of intellectual functioning was within the bottom 5% of the adult population, and she was suffering from avoidant personality disorder, dependent personality disorder, and borderline personality disorder. He gave evidence that these personality disorders, particularly the dependent personality disorder, would have significantly impaired the appellant's ability to stop McClure from hurting the child. The evidence was that on previous occasions she had not intervened at the time of the assaults, apparently because she thought it was inappropriate to argue in the presence of the child, but had spoken to him afterwards to no avail. In the context of the question whether a parent witnessing an assault on a child could reasonably have acted to protect the child, it is not appropriate to test the matter by reference to a hypothetical reasonable parent. Rather, the test is whether the particular parent, with all her personal characteristics, and in the situation in which she found herself, could reasonably have intervened to prevent the assault. The trial judge said, "Then I want to turn to the following phrases. Failed to protect her welfare. Failed to protect her and ensure her well-being." Now those phrases incorporate, as Mr. Davidson rightly said to you yesterday, the concept of reasonableness. So you should read those phrases as doing what was reasonable to protect her and what was reasonable to ensure her well-being. And of course, what was reasonable will depend upon the particular circumstances. So, for example, it might be reasonable to expect a mother to do one particular thing by way of protection of her child or of ensuring the well-being of the child, but in other circumstances it might not have been reasonable to have expected her to do that thing. It might be asking too much in those particular circumstances, so you have to consider the particular circumstances. In particular, though, she is not obliged to put herself in serious danger. The law does not call for any heroics in such a situation. The appeal court held that these directions didn't give the jury sufficient guidance on what was an important issue in this case. They should have been given guidance as to what circumstances might properly have been regarded as relevant to the reasonableness of the appellant Andrea Bone's actions and omissions. In particular, it was important in this case that the jury should have had an explicit indication that it was relevant to the question of reasonableness to have regard to the physical and psychological condition of Andrea Bone, and that in that connection they should have regard to the evidence of Professor Cook. There was therefore a miscarriage of justice in this regard. That is sufficient to result in the allowance of the appeal and the quashing of the appellant's conviction for culpable homicide in respect of charge 2. Now, many may say that they are concerned about the fact that Andrea Bone was exonerated, and I'd be interested to know what you think about that. Do you think that she should have been found guilty of it in the first place? Do you think that the appeal court was right? But let me just say this. The appeal court don't exonerate people, and they didn't exonerate Bone. Nor did they say that she wasn't culpable. What they said was that directions to the trial judge did they say she was not culpable. What they said was that the directions the trial judge gave the jury were wrong. It simply means that the conviction was unsafe because of an error by the judge. Following the appeal, Andrea Bone spoke to BBC Reporting Scotland on Friday the 18th of November 2005 when she said this: "I am relieved I can finally grieve for my daughter. I can finally get on with my life and grieve for my daughter, which I have been bottling up for so long. And now I can get the help I need." Andrea's father and Carla-Nicole's grandfather, Carl Bone, said, "I don't agree with her getting away with it totally. I never agreed with her going down. I have always felt that she should have got help and had probation and been forced to get medical assistance to sort her out. But to quash it completely, I'm afraid no, I don't agree with it." Now, the reality is that the appeal court don't really get a choice. They can either quash a conviction or uphold it. There's then a decision to be taken about whether the trial should be run again, but given how far after the offence it was and the fact that she only got 3 years in the first place and had spent time on remand, it would be unlikely that it would be in the public interest to go through an entire trial again with the expense that's involved and the re-traumatisation for the people who have to give evidence. Liz Berry, Carla's paternal grandmother, said that Bone should have been strung up. She said, "As far as I'm concerned, that woman's still a killer. When she was in prison, I just had to go to see her. I got in by promising her a packet of fags. No one knew I'd gone. I stared her in the eyes and told her, 'If you ever come near my son again or any of my family, I'll kill you.' No one knows what David's gone through. He's gone absolutely ballistic at this decision. As far as he's concerned, Andrea Bone can rot in hell. He said he wouldn't spit on her if she was on fire. Carla-Nicole was born on my birthday, and it's a memory I have to live with year after year. There's no way Andrea Bone is innocent. What mother sits by and does nothing? I'd do life for my children if anyone was to touch a hair on their head." Andrea Bone may be out, but people will always know what she did. She can change her name, but she can't change her looks. Unfortunately, I wasn't able to find anything at all about what happened in relation to Andrea Bone's sentence. So we know that she was sentenced in 2002 to 3 years in prison. We know that she spent some time on remand and some time on bail, but it isn't clear whether or not the appeal court ever dealt with her sentence. Now, following that appeal hearing, there was one final thing, which was an independent inquiry at the request of the North East of Scotland Child Protection Committee. The report authors were Anne Black and Anne Bergham, and they said this: the report finds the work with Carla and her family by professionals was extensive and that much was done to try and secure a better level of care for her. Carla-Nicole was known to care services in Grampian NHS Trust, Aberdeen City Council and then Aberdeenshire Council. Various care workers found bruising on Carla-Nicole's body, but a lack of continuity in care meant that changes may not have been spotted. There was no agreed care plan by social work and health staff, and also a reluctance amongst some to challenge the baby's mother about her standards of care in case she disappeared. Ms. Black added that there was no way of predicting McClure's actions. She said, "It is very hard to know just what violence is inside a person, and certainly from the records we read, from interviews with staff, the man who killed her was acting as a caring parent in all the contacts that professionals had with him." The review said that those working with vulnerable families should have a clear, shared plan, an objective set for the work to be undertaken, ensure continuous have a clear, shared plan and objective set for the work to be undertaken, ensure continuous contact with the families in order to be aware of small but sometimes significant changes in the child's care, ensure that information is shared and reviewed, and keep records in chronological order. It also stressed the responsibility for protecting children rests with the whole community, and agencies need the collaboration of members of the public to allow them to fulfil their duties in protecting children. Even if all the proposals and recommendations within this report were to be fully adopted by everyone, no agency or group of agencies will be able to prevent all child deaths or child abuse. Now, unfortunately, I agree. The reality is that we cannot prevent people like McClure from being violent. What we can do is make small changes. All of the time, we need to reflect on what is working and what is not working, and where we see that something isn't working, change it. And we do need members of the public to help the authorities and to tell them about what they can see, because a social worker may see a child once a month. A neighbour may see a child once a day. And so it's important that members of the public help out where they can and provide information that's going to help authorities to step in and protect children. I want to extend my sincerest condolences to all of the family that is left behind by Carla-Nicole Bone. I cannot imagine the pain that you must have felt and must still feel. But I hope that in telling her story, we can do two things. Keep her memory alive and prevent things like this from happening in the future by raising awareness and spreading education. We'll leave it there for today. Next time, I'll be back with more in-depth analysis of a recent case. Thanks for listening, and I'd be really grateful if you could comment, share the episode, and if you're listening on a podcast,